Welcome to the ABCs of Intellectual Property, and we have two panelists today. And our first panelist is Brett Harris, and Brett is a third-year law student at the UA Little Rock William H. Bowen School of Law, and he's taken advanced intellectual property coursework as a visiting student at the University of Illinois at Chicago Law School, and he hopes to specialize in intellectual property law after graduation. Now, prior to attending law school, Brett obtained his Bachelor of Science in Management from the Arkansas State University and has worked as a textbook distributor focusing on intellectual property issues. And also joining Brett is his mentor down at the Bowen School of Law, and that is Dr. Kimberly Vu-Dinh. And you may remember her. She's been on to do a couple webinars for us regarding some of the legal aspects of owning a small business. And Dr. Vu-Dinh runs we have a small business legal clinic down at the Bowen School of Law that you might want to take advantage of sometime. They do some very interesting work with small business down there. And we're very glad to have both of you. So I understand Brett's up first. So let's go ahead and take it away, Brett.
Thank you for that introduction, Timothy. And thank you all for joining us for part one of our intellectual property workshop series. As Timothy said, I'm Brett Harris, and I'm also accompanied by Professor Kim Vu-Dinh, who is the Business Innovations Clinic Director here at the Bowen School of Law. We're really excited to be working with the Arkansas Small Business and Technology Development Center and collaborating together in producing this four-part workshop series. And for those of you that aren't familiar with the Business Innovations Clinic's work, we really focus on assisting small businesses and nonprofit organizations with various legal matters, all with the goal of driving social and economic community improvements and betterment. As Timothy said, if you have any questions throughout today's presentation, please feel free to enter those into the appropriate pane. And there will be some parts of the presentation that are designed for feedback. So please feel free to be as interactive as you would like in today's presentation. Before we begin today's presentation, we do need to share this brief disclaimer that the contents of this presentation are for educational and informational purposes only. This presentation is not intended to replace or substitute professional advice that you would get from visiting or seeking counsel from an attorney. Any interactions that we have in today's workshop do not form an attorney-client relationship. So with that, let's jump right into what is intellectual property. And intellectual property is something that, you know, as a small business owner, you probably hear different parts of intellectual property, but you may not know or understand exactly what all intellectual property encompasses. So at a basic level, intellectual property is the work product resulting from the human mind or the human intellect that is legally recognized for protection. And that definition is really broad. As you can imagine, that encompasses several different areas and different tools within IP. And we're going to be talking about each of those tools throughout today's presentation. And then we'll be diving more in depth into the specific areas and tools of IP in our subsequent workshop presentations, which we hope you join. The overarching theme of intellectual property or goal is that intellectual property really tries to motivate authors and inventors to continue being innovative and creative in producing new inventions, new works, things of that nature. And it does so by trying to ensure that the inventors and authors are receiving their proper compensation so that they really can have the funds to continue driving the innovative activities that they do. So with that, let's take a look at really 4 different distinct tools for intellectual property. The first is obviously copyright, and then the second is trademark. And copyright and trademark are often confused between each other, and we see this a lot in the clinic. Clients will come to us saying, you know, hey, we need to copyright our brand name or something like that. when in reality that would actually be a trademark. So hopefully by the end of today's presentation, you'll be able to have a basic understanding of the differences between copyright and trademark, and be able to distinguish those. And then we also have patents and trade secrets, which are both closely related to each other as well. Copyrights, the basic definitions, I'll walk through the definitions, and then we're going to be breaking those definitions down throughout the remainder of today's presentation. So copyrights protect original works of authorship that are fixed in a tangible medium. And again, we're going to be breaking this down, but we'll be really focused what is an original work, and what's a work of authorship, and then last, what is the tangible medium of expression. And then with trademarks, trademarks are marks that protect identifying marks used in association with goods and services in commerce. So again, this is something that's somewhat confusing with copyright, but it is more geared toward consumer protection. And we'll talk more about that later. And patents protect inventions of the underlying designs of technology, product, formulations, and other utilitarian items. And then last, we have trade secrets, which protect certain inventions, assets, information, secrets owned by businesses that have an economic value. So with that, we'll jump right into our first pop quiz, and we'll see how this works in today's function. So if you can, please respond back with what you think the answers are. So starting with number 1, you should copyright your business name. And as a reminder, you can submit your responses via the questions pane.
I think you have a shy group.
Okay. Yeah, for sure. So feel free, like I said, please feel free to chime in throughout. So we'll start with number 1. A copyright of the business name, as I kind of briefly already mentioned once, that is in fact a trademark. So you should be trademarking your business name rather than copywriting it. Number 2, you should patent a new custom necklace design that features a new clasp that can be secured easily. And here again, this is actually true. This would be a utility patent, which we'll talk more about. And then number 3, you can claim trade secret protection of a cookie recipe if you sell your cookie recipe in a cookbook. And here on number 3, once you sell your exact recipe, then it is no longer a secret. It has been publicly disclosed, so it is not eligible for trade secret protection. So with that, let's jump right into copyright. And again, the definition of copyright is that it protects original works of authorship that are fixed in a physical or tangible form. And it seeks to protect these works by preventing others from using an author's work without the consent or authorization of the author, and in certain instances, without compensation. Or it helps to protect the compensation is granted to the author for use of their work. As we briefly mentioned, works of authorship are really the areas where copyright protection is available. And as you can see, this list is a very comprehensive list. So when we say literary works, think novels, poems, essays, anything that's really a written literary work. So if you wanted an actual example, the Harry Potter book series would be an example of a literary work. The second one is musical works. And here, musical works is kind of a very broad encompassing area of authorship. So it can include anything from the underlying composition of the work, meaning the actual sheet music, to a symphony song. It can be a render, the actual lyrics to a song. So, you know, if you think about a famous singer-songwriter, you have Dolly Parton, who wrote many of her famous songs. So here she would have the musical right copyright to songs that she wrote herself. The third category is dramatic works, and this includes things such as plays, Broadway production, theater productions, anything of that sort. So here, think like Hamilton, the famous Broadway play, or even the Phantom of the Opera. The next area of work of authorship is pantomimes and choreographic works. And here you don't really see a lot of pantomimes in modern day times. So this used to be a much bigger thing than it is now. But we're really seeing choreography, excuse me, really becoming more prevalent in copyright protection. So that is, you know, the specific dance moves associated with a work, and those dance moves obviously again have to be in a fixed tangible form, and we'll be talking about exactly how that's done in a couple slides. The next category is pictorial, graphic, and sculptural works. So here, this is what I like to call the fine art category. So you have anything, you know, you can think paintings, you can think sculptures, you can think pencil sketches, things of that sort. Then we have motion pictures and other audio-visual works. Motion pictures is kind of the more obvious one of that. So that's going to be your Hollywood motion pictures. Going back to the Harry Potter reference, you know, the Harry Potter movies are motion pictures. Other audiovisual works is somewhat of a lesser known category of that. And audiovisual works really encompasses a lot of different things. So at a basic level, anything that has a audio component to it, as well as accompanying synced graphics, such as the recording of today's presentation would be an audiovisual work, or you know, even the famous "I Have a Dream" speech by Martin Luther King Jr. Would be considered an audiovisual work. The next category is sound recordings. And sound recordings can be, you know, recorded text, recorded speech. It can be something, it can also be particular versions of songs. So if, you know, if you have a cover version of a song, that would be considered a sound recording. And then last, we have architectural works. And architectural works are really relatively new to copyright protection. They were added in the 1990s for protection. And here, architectural works refers to really what the aesthetic and overall feel of a building when you look at it from the exterior that's viewable from the public's perspective. So when you're thinking of architectural works, you know, for example, obviously one of the most famous examples is the One World Trade Center in New York City has a very unique and distinct design. And that design would be protected under as an architectural work. So next, we're going to break down the definition even further by defining what is an original work. And an original work is something that is created independently by the author, but it has to have at least some minimal degree of creativity contributed by the author to the work itself. The minimal degree of creativity is something that's rarely not met because it's a relatively low threshold. And it can be, you know, a minimal degree of creativity can be something as simple as the author's choice in arranging and laying out, for example, a phone book or something of that nature, where you're taking different pieces of data or different works, compiling them together, and that forms what's called a compilation. And that, you know, that meets the minimal degree of creativity threshold. So again, it's kind of rare that we don't see a minimal degree of creativity, but it is still something that you have to keep in mind. So next, let's take a look at what being fixed in a tangible form means. And this one is the part of the definition that is probably, in my opinion, the least clear at a face value reading of it, because what does it mean to be fixed in a tangible form? Well, it's actually pretty simple. It just means that the work has to be recorded so that the author can take the work and share it, or so that other individuals can experience the work exactly as recorded by the author. So, in today's day and age, there's several different ways that you can physically share a work. And, it can be something as simple as being printed on a piece of paper, or in today's day and age, it might be housed on a server's hard drive in the cloud. Either way, it all comes back to, is the work being able to be reproduced or shared to others exactly as it was reported by the author? So now you may be thinking, wow, copyright really covers a lot of different stuff. Yes, it does, but it does not cover everything. And some specific examples of stuff that it does not cover includes mere ideas, and that goes back to it being fixed in a tangible form, because in order for there to be copyright, it has to be recorded so that you can share it with someone else. Well, if it's just an idea in your head, you can't share the exact work with someone or to let them experience the exact work. Copyright does not protect procedures, method systems, processes, concepts, principles, discoveries, or anything of that sort. And that's because primarily a lot of these different areas are protected by other tools within the IP realm. Copyright also does not protect works that are not in a tangible form, which we just covered. And kind of what we see a lot of confusion on here in the clinic a lot is copyright does not cover titles, names, short phrases, or even slogans. And the last one, slogans, is kind of surprising to a lot of people, I think, because you would think that, text could be considered a literary work, but in the context of a slogan, it is actually eligible for protection under trademark rather than copyright. Last, copyright does not cover mere variations of ornamentation, lettering, or other stylings. So that just means that you can't have copyright on a work that you take from someone else, copy it, and just change the font and the size, or the way the document or the contents of the text look. That does not meet the minimal degree of creativity threshold. So copyright does not protect those mere variations. And then also, copyright doesn't protect familiar symbols or designs. So here, think of things that are universally known or that are universally used. And the idea of why copyright doesn't protect that is because you can't protect something that is already in use by everyone. You're not going to give the exclusive right to a single person to use something that's already universally known. So now, probably the most burning question on everyone's minds, especially small businesses and entrepreneurs alike, is how long does a copyright last and how much does it cost? So copyrights are typically protected for the duration of the author's life plus 70 years. And to kind of restate that a little bit differently so that it's easier to understand, is copyright lasts for 70 years after the author's death. And again, this is for new copyrights, and there are some exceptions to this. So it's not across the board, but this is kind of the generalization of that. And then after the copyright expires, the work enters what's called the public domain. And works that are in the public domain are free for use by anybody without compensation to the author. So if a work is in the public domain, I can go grab the contents of that work. I can do whatever I need to do with that work. I can even repackage it, change it, and I can even sell it without compensating the original author of the work. And then the cost associated with copyright protection is generally can range anywhere from $250 to $500, possibly more in some situations. And that's if you're going through using an attorney, which is suggested for copyrights. So here we're going to jump into another pop quiz. And really the question here is what is depicted in the graphic below protected by copyright? And if you would, feel free to respond into the questions on the panel.
Well, Nicholas has ventured a no.
Okay.
And
so
Gretchen's also
looking at this,
no, as is Destiny.
okay. So
real
looking
quick,
at this,
one quick comment is, I'm not sure why, but usually the silhouette is dancing. Okay. There you go.
Yes. So here, the silhouettes which are dancing, this is representative of choreography. And here, the reason it is actually protected by copyright under the works of authorship category of pantomimes and choreography. And the reason this specific one is important, or why I chose this for the pop quiz, is because the actual choreography that is depicted here is the first modern pop music choreography that has been officially registered for protection with the United States Copyright Office. And this is from the Singles Ladies video by Beyonce. So this is kind of a pioneering movement in choreographing modern music video dances and things of that sort. So as you'll see, I figured this will become more and more common, and you'll see probably some legal issues spawning over choreography in the coming years. So let's jump forward to our next tool, which is trademarks. And trademarks are words, names, symbols, devices, or even sounds, or any combination thereof. And really a trademark, the combination of the words, the symbols, devices, anything of that sort, that at the end of the day, they are used to distinguish the goods of one person from another. And ultimately, you know, trademark comes back to indicating the source or origin of the goods or services. So as I kind of briefly mentioned at the beginning, trademarks are really consumer centric because they focus on how consumers perceive goods and services. And it all comes back to several factors that are related to consumer protection, such as providing consumers with shortcuts and fostering brand goodwill. And really the best example I can give you is you going to the grocery store and you're looking for your favorite brand of ranch. And typically, you know, when you go to the grocery store, you don't spend a whole lot of time looking for your particular brand or whatever you're looking for. You typically are able to identify it quickly, grab it off the shelf, and go about your business. Well, that right there demonstrates the entire purpose of trademarks. So if your favorite brand of ranch is Hidden Valley, you know instantly what the bottle looks like and how the branding and the labeling of the bottle itself appear. So you're able to quickly identify it on the shelf, grab it, and go about your business. Well, without trademarks, you would have competitors trying to get confused consumers. And essentially what I mean by that is you would have individuals coming in and saying, oh, okay, Hidden Valley is a very popular brand ranch. Let's call our brand Hidden Valley, but spelled differently, or something similar like that. Make it look as close to it as possible, sell it. Consumers will be confused. Well, that illustrates right there the entire purpose of trademarks. So trademarks protect their owners' intellectual property by keeping competitors away from being confusingly similar, and they also punish free riders and copycats. So what should a trademark not be? Well, you know, unfortunately, this list is unfortunately very common, especially with startup businesses, and we see this a lot in the clinic as well. Individuals will be coming to us and want to trademark their business that they just started, but their business name is essentially either their last name, first name, something like that. Well, a trademark should not be names, because generally a name is not eligible for trademark protection unless it has acquired distinctiveness or achieved secondary meaning. And for something to have acquired distinctiveness is very difficult to prove. And it's also very costly, because acquired distinctiveness requires, number one, that the person applying for the mark or registration have held a similar mark that was registered. And then also it requires that there have been at least 5 years of continuous use of the mark itself in commerce. And then last, that consumers recognize the product and associate it with the particular goods or services. So as you can imagine, that's very difficult to prove, and almost, you know, certainly in a startup business or a very small business, you're not going to be able to meet the threshold proving acquired distinctiveness. So for that reason, we generally say to avoid naming your business with names. And also, a trademark should not be generic. So what we mean there is a trademark you shouldn't be seeking protection for your business name if your business name is calling a product whatever the public or average consumer knows the product as. You can't trademark that down. So that comes back to what is universally known by the consumer. So for example, Bayer aspirin, Bayer actually held a trademark for aspirin for several years, but over time consumers referred to the product as aspirin whether or not it was Bayer. It could have been made by some other pharmaceutical company. They still referred to it as aspirin. Well, that made the mark become generic. So keep that in mind. You can't you can't protect something that is universally known to consumers as the product or good or service itself. Also, trademarks should not be merely descriptive. And this one is fairly obvious, especially when I give an example of if you have an ice cream brand and you want to call it cold and creamy. Well, cold and creamy is just mere description of what ice cream is. So something that is merely descriptive is not eligible for trademark protection. Trademark should also not be geographically misdescriptive. And this one's a little less inherent or understood why. So what we mean here is geographically misdescriptive. If you have a product, for instance, if I am selling Icelandic glacier water, but the water is actually bottled here in Little Rock, Arkansas, well, that's geographically misdescriptive because consumers are going to automatically assume and associate that the goods are originating from Iceland and that they're coming from glacier water. But in reality, it's coming from the city of Little Rock's municipal water source. So you can see why that's geographically misdescriptive. So again, trademarks here act as a tool of consumer protection. So we're protecting consumers from being deceived or things of that sort. Last, a trademark should not be already in use by someone else or be confusingly similar to someone else's mark. And I'm really going to dive a whole lot more into this in the next slide, but you've heard me mention this over and over again, is trademarks really want to know what consumers perceive. and it tries to avoid consumer confusion so as to encourage the actual origin, identification, and brand goodwill of the origin of the goods or services. So let's take a closer look at likelihood of confusion, and let's talk about that for a little bit. And here, likelihood of confusion is just the potential for a mark to conflict with a pre-existing mark. And, you know, like I've already said before, is it's really, the likelihood of confusion is really driven by what consumers are thinking or perceiving. So the question is, will consumers be confused by brand X, Y, Z? And, you know, you have to look at that, and there's several different factors that you look at in determining consumer confusion. And then oftentimes, you know, sometimes it even comes down to conducting surveys of consumers to understand what consumers are really believing. So a general rule of thumb is it is really, really good to just avoid likelihood of confusion altogether on the front end. So if you see that someone else is using a similar name, avoid it altogether. And we have a couple of examples here. So Sky Cosmetics is already in existence. And you'll notice that Sky is spelled with an E at the end, but it is still pronounced Sky Cosmetics. And if you have a new business, you're starting a new business and you're wanting to operate a Sky Blush, well, can you get registration for Sky Blush when Sky Cosmetics is already in existence? And here there's a couple different things to really look at. So number one, we have the spelling difference in the word skies. And then number two, we have to look at, okay, well, what products are they really selling? Or what classifications are they falling within? So blush is generally known as a type of cosmetic. So it's likely that, you know, it's in the same product class. It's going to be similar consumers that are consuming or using the products of both Sky Cosmetics and Sky Blush. So looking at it, the first part of that is, okay, so blush and cosmetics are very similar. So then is the first part of our name similar? Well, the phonetics or pronunciation of Sky and Sky with an E are essentially the same. It doesn't matter that the spelling is different. So you'll see this quite often where companies will try to get clever and, you know, they might replace a letter with a number or even a symbol or something like that. But at the end of the day, the pronunciation or the phonetics of the word itself or the mark itself is still confusingly similar to the existing mark. So that just really illustrates what the likelihood of confusion is. So with trademarks, you know, their duration is issued for initially a 10-year term, but you have the option of subsequent renewals. However, I will caution you that the trademark protection is entirely dependent upon actual use of the mark. So for instance, if you have a trademark registration for a mark, but then you stop using it, you know, say after 1 year, well, you're not going to be eligible for renewals. And then especially in your first term, you at year 5, you have to file an affidavit stating that you are using the mark in commerce. Well, if you fail to do that, you lose your trademark registration. So as you can see, you know, trademark, it's all about using the mark exactly how it was depicted on the application itself. The actual cost of obtaining a trademark is what I would consider moderate compared to the other IP tools. And with counsel, you can expect to pay anywhere from $500 upwards to $2,000, sometimes more, to obtain a trademark registration. I will say one thing that really impacts the cost of trademark registration is the number of classes which you seek protection. And what I mean by that is, going back to our Sky Cosmetic example, there may be one or more categories. So it could, for instance, let's just say that cosmetics has 3 different categories they would like to seek protection in. Well, they're going to be paying the filing fee for all 3 of those areas. So you can kind of see how your cost increases pretty quickly the more areas that you're trying to seek protection or registration in. And with that, let's jump into our pop quiz for this section. And here it's just a multiple choice question. Which of the following marks could be potentially eligible for trademark registration? So we have A, sweet and creamy gelato, B, Cooper's Country Cooking, C, 9 Key Shoes, D, none of the above.
Destiny's going to venture a C on this one. And I think everybody else is just holding in reserve, waiting to find out what the correct answer is. Gretchen's going to venture a B.
Okay,
And
so let's
Nicholas is none of the
just
above.
talk about these. Okay, so the actual correct answer is none of the above here, but let's really talk about each of these options and kind of recap why it's none of the above. So starting with option A, sweet and creamy gelato. The term sweet and creamy could be used to describe gelato itself. So it is likely that that mark would be merely descriptive. And if you'll recall, marks that are merely descriptive are not eligible for trademark protection. Option B, Cooper's Country Cooking. So here, there's a couple different issues at play. With the first word, Cooper's, presumably that's probably a surname or a last name. So if you recall, we said that in order to register a name, you have to show acquired distinctiveness. So we're assuming that this is probably a new startup and would not be able to prove acquired distinctiveness under that. So for that reason, Cooper's Country Cooking would not be eligible for registration. But also there's another potential issue with that, in that the country cooking portion, if the restaurant is entirely just country cooking, that could be, again, potentially merely descriptive of the goods or services themselves. Option C is 9 Key Shoes. So here we have a kind of a play on words, but the phonetic sound is very similar to Nike shoes. And obviously Nike is a very famous brand. So here, 9 Key would cause a likelihood of confusion. So for that reason, it's not eligible for registration. So the correct answer that leaves you with is none of the above. So with that, let's jump into our next area or tool for IP, and that is patents. And a patent is a type of property right issued by the United States Patent and Trademark Office. And you'll hear me refer to the United States Patent and Trademark Office a lot, especially in the subsequent presentations by the USPTO. And that property right is granted to inventors of new ideas and developments and inventions. And a patent acts as a type of property right in that it gives the owner of the patent the exclusive right to market, manufacture, distribute, sell their product for a certain period of time exclusively. Or they can assign their rights to another individual or anything of that sort. But essentially, it gives an exclusive use to, or exclusive right to manufacture or sell a specific product or invention that's been created. And with patents, it has to be a new and useful invention, or a new or useful process to qualify for protection. So as used in patent law, the term useful just means that the invention or process, number one, is operational, and number two, that it produces a beneficial output. And that beneficial output can be, in various forms. So that's really a broad term, as long as it yields some type of benefit as a result of operation. It is useful. The term new, as used within patent law, means that the topic of it or the subject matter has not been patented before or used in the world, whether or not that was with or without a patent. So the term new means just that. It has to be something new that's essentially never been seen before. And looking at the subject matters that are eligible for patent protection, you have these main categories, which are machines, processes, compositions of matter, which compositions of matter can be something, you know, like it could be a pharmaceutical composition of a drug, or it could be something more simple like a secret spice recipe that you have, or stuff like that. And species of plants, and last, designs of useful inventions. So there it's referring to the actual design of the invention itself rather than the actual invention. So we really have three different types of patents, and there's three different types of patent applications, and these are those types. First, we have utility, which is by far the most commonly used, and that's because it's very broad and encompasses any new or improved useful process, invention of a machine, or composition of matter. So you can see that that kind of covers a whole lot of different areas. And then we have design patents, which protect the underlying design of manufactured goods. So again, just note that that's the actual design and not so much the function of the invention itself. And then last, we have plant patents, which is just for new and distinct varieties of plants. So the process of obtaining a patent is very complex. And by complex, I mean there's several different steps along the way, and all the steps have to be done with 100% accuracy. And that's because if after you submit a patent application, that patent application becomes a part of public record. And the reason why that's important to note is because of the fact that once something has been publicly disclosed, it's no longer new. Therefore, it's not eligible for patent protection. So, you know, this is why I cannot tell you strongly enough, you need a patent attorney or a patent agent to assist you in obtaining a patent, because there's just so many different areas to make a mistake. And like I said, a single mistake is really fatal to your invention forever. And then other individuals can come in and use your good or service or your invention, excuse me, for any reason. And no compensation to you as the inventor. So on our screen, on this left-hand side, we have a design patent application. And this particular one is for an Apple laptop. And you can see it has a rendering of the laptop itself. It also has the list of inventors. It has some dates, and then it has technical descriptions of everything that's encompassing. But to the right, we have a utility patent for an aircraft. And as you can see, the rendering for it looks way more complicated than the design patent. You have numerous points on it, and those are all referring back to technical descriptions of exactly what is protected, how it all works, and what the output is. So again, as you can kind of see here, the takeaway from this is please seek assistance from a patent attorney or a patent agent, because again, it's such a complex process. And because it's so complex, patents are the most expensive tool within IP to obtain. A single patent can range anywhere from $5,000 to $10,000 and even more in certain situations. You know, so they are very expensive to obtain, but it's because, you know, again, everything has to be 100% correct the first time. There's no room for mistakes. And they also require a great deal of research and time preparing the application itself. In terms of duration, patents expire 20 years from the date of application filing. And this is kind of important to note because this is a relatively short amount of time. So again, you have a period of 20 years from the time you file your application before anyone can come in, use your invention, copy, produce it, sell it as their own with no compensation to you. So that is something to always keep in mind, especially if you're even thinking about getting a patent. Just remember that try to think is a patent really the best way of achieving the longest protection for what I'm trying to protect? So now let's jump into trade secrets, which are closely related to patent. And here the reason I say that they're closely related is because in the duration of patents, some things that are eligible for patent protection can actually be protected through trade secrets. So if you have a product formulation, such as the Coca-Cola recipe, it could be protected by a trade secret instead of a patent. And there's some definite advantages to that because of the duration, where patents are a 20-year duration. Trade secrets can be essentially infinite because as long as they are maintained properly by taking reasonable measures to protect the secrecy of the information, and it remains a secret, it can stay a trade secret and have the trade secret protections essentially forever. So, that's one thing to really keep in mind is, do I really need a patent, or is that the best type of protection? Because what would have happened to Coca-Cola if they had filed for a patent? Well, everyone would have had the recipe, can come in, copy it, and they would have lost tons of money. Whereas today, they're still able to produce Coca-Cola and capitalize on the invention because they've kept it a secret. And a key to trade secrets in general is that, if something is easily reverse engineered, it's probably better for patent protection. But if it's not easily reverse engineered, such as Coca-Cola's recipe, then it's probably better suited to be protected as a trade secret. And you may be asking yourself, well, how do I keep something a secret? Well, beyond the obvious of not telling anyone, there are some tools that help you keep trade secrets a secret. The most common one is the non-disclosure agreement, or NDA. And NDAs are just a written agreement between the parties that typically delineates what information is being shared, how the information is to be used, and binding the recipient of the secret information from sharing that information with anybody. And then, trade secrets, as I've already said, their duration is essentially perpetual, meaning that as long as it maintains economic value and is kept a secret, it can remain protected. Kind of following that same linear thought process, the costs associated with trade secret protection are really dependent entirely on the steps and actions that you're taking to protect the secret itself. So, a baseline for just a basic NDA might cost anywhere from $250 to $500. But we do recommend that you seek professional counsel in helping you formulate or develop the non-disclosure agreements, just because they are so critical, and you want to make sure that it's valid and enforceable so that your trade secret is not inadvertently disclosed. So with that, I would like to remind you of our upcoming workshops in this series. We have one this Thursday, July 8th, Introduction to Trademarks, and then we have Introduction to Copyrights, and then we're concluding with Introduction to Patents and Trade Secrets. We also have our, we will be releasing Iptool Kits, which are written guides to all the different tools of IP that we're talking about in this workshop series, and they go much more in depth than our presentations do. And it gives you a written guide on how to do what. And then with the toolkits, we have accompanying IP primer videos that kind of walk you through the toolkits. And with that, if you have questions or anything of that sort, feel free to ask them in the questions function. And then also, we recommend that you visit copyright.gov if you have questions about copyrights, or if you have questions about trademarks or patents. The website for that is uspto.gov. So thank you very much for joining us today. And with that, Timothy.
All right, good job, Brett. That was a really great overview. And we did have a few questions come in back when you were discussing copyrights. Nicholas asked, what about the Just Do It that Nike puts on all their stuff?
So Just Do It would be a trademark because that's part of the trade dress associated with Nike. And as you'll recall, a slogan is not eligible for copyright protection.
All right, and Nicholas also had a question. Nicholas,
Can I follow up? So the clarification there is, it's not that the slogan is trademarked. It's that the way it's printed in the font and the affiliation with a sports company, that is what's trademarked. But anyone can use the slogan Just Do It for their own company, so long as it's not being used with that font to affiliate in the different classes that Nike probably has it registered in. So you see the difference between copywriting that, right? Because copywriting it would be preventing anyone from saying Just Do It, which that's not going to happen in this country. But trademarking is saying you can't use that font and those words on t-shirts and commercials, et cetera, for an athletic company.
all right.
Does that make
I think that's clear. And similarly, Nicholas had a question about the animated GIF that was showing the choreography. He said, so a GIF can be copyrighted?
So Brett, do you want to chime in there?
Sure. So for clarification on that, we were asking about the choreography of the dance moves itself depicted in the GIF rather than the GIF itself. So there it was, the choreography from Single Ladies by Beyonce is in fact a registered copyright. And then Professor Vu-Dinh, do you want to clarify further?
Yeah, and so that GIF, you can think of that GIF as a written expression of that copyright. So, right, so that's one of the ways Beyonce might have recorded, taken to pen and intangible form her choreography. So that means others cannot take to tangible form that choreography. So in a sense, she owns that GIF because it's the choreography that she came up with, right? So we're able to use it because of the fair use doctrine, and we're using it to teach. And you'll learn a lot more about the fair use doctrine if you attend the next workshop on copyright.
Great segue. And Joy noticed when you were talking about trademarks and names, said, so Tesla being a name originally, now you've got Tesla Motors owning it. Could someone challenge Tesla's current trademark?
So a couple of things there, right? Tesla can't stop someone having that name, right? So they have a company, but that doesn't mean that they can stop people, Tesla's descendants, for instance, from having the name Tesla, right? And it's a personal name. And at this point, it has that acquired recognition that Brett was talking about to now come to mean, oh, you're talking about the energy efficient, automotive and other, they do a million things, right? So at this point, it has that acquired meaning. and he can use it for that company and preclude others from using that name for the classes he registered in, right? So this doesn't mean that he can preclude a fruit company from calling itself Tesla, or he also just can't preclude anyone from using that name for their company who has it as a personal name, unless it's in that class that he has registered that trademark in.
All right.
He means Elon Musk.
And Destiny, you want to know, what if an existing trademark is listed as dead on the trademark website?
That can mean a couple things, Brett. Do you want to go through that? Yeah.
Yeah, so that there's actually several different things that can mean, and basically the best advice I can give you there is it can mean that the mark was abandoned after it's granted registration. So typically, if a mark's abandoned, it's for non-use, and we're really seeing a real progression in abandonment because it can now. And trademark can be abandoned in as little as 3 years of non-continuous use. But also, dead can mean that the application was not granted in the first place by the United States Patent and Trademark Office. And then there's some other things that it can mean as well. But the best way or the best advice I can give you on that is you want to open the dead listings or the dead registration itself. And then you can click TDSR and retrieve all the documents associated with that mark registration to determine exactly why the mark is dead. And we'll be talking a little bit more about that in our Introduction to Trademarks workshop series. So if you want to learn more about that, I would strongly encourage you to attend that session.
Okay.
And, hi, for example, it might, when someone, so just to lay out that process real quick, the trademark examiner is communicating with you regularly. They say, hey, your specimen isn't clear enough, right? Or they'll say, can you clarify what you mean here? Did you mean all baked goods or just cupcakes? And that conversation with the trademark examiner is all public, and you can click on that and see all those correspondence if you click on that TDSR. So if it says dead, you'll want to read through that correspondence to figure out, is it dead because the person said, I don't have a chance, I'm just gonna let this go, right? Because if they decide to do that, that application is not revoked from the public record. It's still there for you to see why the what the examiner said to the person. Sometimes it's a little hard to understand what they mean in their language, and that's when you'll want an attorney to help you interpret that to figure out if it's dead because they didn't bother anymore or if it's dead because they didn't really have much of a chance.
Okay, switching back to copyrights, Gretchen wants to know, should a family history book be copyrighted?
I mean, I guess the follow-up question is, why do you want to copyright it, right? So are you intending to publish it? So first of all, as Brett pointed out, it's already copyrighted once it's hit paper. If you have it in a tangible form, but I guess you're talking about registration, right? And so generally you register something when you have a concern that there might be an infringement of some sort. So an easy example to think of is, I use him as a guinea pig a lot. My husband is a songwriter and he's a musician and has a band, and he's written hundreds of songs, but he's only copyright registered like 50, because he's only put out 5 albums and put them on the internet, right? So for him, it's not really worth the time and energy until he put things on the internet and he's put YouTube videos and stuff like that, and there is that risk of copyright infringement. So it's certainly up to you, and it really depends on what your intentions are before you register it. But it's already copyright protected by the fact that it's in a written form, a tangible form.
Okay, our last minute questions from Destiny, and she said, can you use the trademark if it's going to be registered in a different class?
So that goes to that. Go ahead, Brett.
Sorry, go ahead.
So it goes to the elements of likelihood of confusion that Brett was referring to, right? So you certainly have a stronger argument when you have the same company name but a different class. But if those classes are very similar and there's likelihood of confusion, that original trademark owner still has a decent argument, right? So some classes can be as close as teaching and like job training and maybe higher education. Those could possibly be separate classes. So it really depends on that. It turns on that likelihood of confusion argument.
All right, that empties out our queue. So I want to thank everybody for being with us today. Again, we are going to follow up in an email. You'll get a link to some more information on the law clinic we have over at the Bowen School of Law. And you'll also get some reminders and some links to register for the next 3 upcoming webinars we're going to have as well. And as always, you can reach out to ASBTDC at 800-862-2040. Visit us on the web. And this video will be up on YouTube before the end of the day. I should have it processed and up and going well before 5 o'clock today. And just a reminder that we are a partnership with the SBA, and we in turn partner with 10 other universities around the state of Arkansas, providing outreach to all 75 counties. And as soon as this pandemic is over with, you'll be able to walk into any one of our 10 offices and get some help with various things. So look forward to you joining us. Actually, this Thursday will be the second one in that series. So come join us again and find out a little bit more in depth about patents and trademarks and copyrights.